everyone. My name is Linda Nyamasoka. I'm a law student at Africa University taught by Mr. Maphosa, the course called The Law of Evidence. I'm going to be doing a presentation on similar effect evidence. Forgive me, this is a disclaimer before I start. I'm only a student, so I'm only basing my facts on the research that I made myself. Okay, so I'll be talking about similar effect evidence. What is similar effect evidence? According to Mr. Vihoe, similar effect evidence is evidence that relates to a matter other than the matter in issue, but which tends to establish effect in issue by showing that similar events have occurred before. This type of evidence is sometimes referred to as propensity evidence or other crimes evidence. There are several requirements that must be met for similar effect evidence to be admissible in court. First, the evidence must be relevant to the matter in issue. Second, the probative value of the evidence must outweigh any prejudicial effect it might have. And thirdly, the evidence must be credible and reliable. Fourth, the evidence must not be unfairly prejudicial to the accused. And lastly, the evidence must not be inadmissible for any other reason, such as being hearsay or confidential. So, when we talk about similar effect evidence, we're talking about other facts that we found out in other crimes, or other facts that relate to other crimes. That is not the particular crime in issue, but that have like a similar trend to like show how this person might have committed this crime, right? So we'll move on to the issue of relevance. Similar effect evidence is only admissible if it's relevant to the matter in issue. This means to say that similar effect can only be relevant when it directly relates to what is going on in the current matter, right? So, for example, if the accused is charged with theft and the prosecution wants to introduce evidence of a previous theft committed by the accused, the evidence will not be admissible if it's relevant to the current charge of theft. That means that the previous must have some connection to the current charge, such as being similar in nature or method. Otherwise, it will be considered irrelevant and inadmissible, right? So this means that the evidence can only be relevant if the previous evidence shows like a similarity in trend, or how in the what can I call it, in the way that the thief stole before, to show that it can relate to the current case. So to add in case law for deeper understanding, I'll make use of the case of State versus Boomer. In this case, the court held that the similar effect evidence is only admissible if it's relevant to the other matter in issue, and if the fact, the probative value of the evidence outweighs any prejudicial effect it may have. The court also noted that the probative value of similar effect evidence must not be overweighed by its prejudicial effect, or else it would be inadmissible. Okay, so this means that if you have evidence from like other crimes or other cases that have been done before, it can only be admissible if it outweighs, the probative value outweighs its prejudicial effect. This means to say that the evidence must not be prejudicial to the accused to have a fair case. Right. Moving on, we'll talk about the rationale for inadmissibility. So like I've said before, similar effect evidence can only be considered if the probative value outweighs its prejudicial effect, right? So because of its potential for prejudice, similar effect evidence is evidence when which pertains a peculiar, immoral, illegal conduct or any other occasion than those in dispute, but also which is of a nature that is logically connected with substantially similar to the conduct which forms substance to the dispute. Similar effect evidence is admissible when it is highly relevant to the issue before the court, right? So the locus classicus of the doctrine of similar effect evidence is, as in the case of Making versus the New South Wales. So in this case, there was a couple, a husband and a wife, right? So they were taking infants into their foster care. They took these infants into their foster care and then took their money for maintenance. But then in this case, the body of the infant was found buried in their backyard. And then now an investigation was opened, and then they found out that they had taken a lot of other infants before, and then those infants died of like unnamed reasons, and then they were buried in a way that was weird, so to say. So in this case, similar effect evidence was applied because there was a trend in which the couple took these children and then they ended up dead, right? So this is how it was admissible. So, like I said before, similar effect evidence is only admissible when the facts are logically connected to the current case at hand, right? Also, similar effect evidence is inadmissible if you have evidence from other previous cases or you have character evidence of the accused, but then it does not relate to the case that is in current issue. Okay, so moving on, we'll talk about the category of relevance. The categories of relevance. So firstly, similar effect evidence has been used for the purposes of rebutting the defense of the accident or coincidence. For instance, in the cases in which justice can't be done without disclosure or prior conduct, such as in the case of R versus Bond, the accused was convicted of using instruments with an intent to commit an abortion on a girl who used to be his domestic worker. The trial allowed evidence to be admitted to the effect that the accused had performed a similar operation on another girl 9 months earlier. Both girls were servants of the accused who apparently had become pregnant by him. Bond was a medical doctor and his defense was that he was using instruments to examine both girls for venereal disease. The court allowed the evidence and proceeded to convict him on the basis of evidence. The court mentioned that the similar effect evidence was highly relevant in that there were striking similarities that the same accident should repeatedly occur to the same question is unusual, especially if it confers to benefit him. Okay, so in this case, similar evidence was admissible because the facts from the previous case were highly admissible in this case. So moving on, we'll go to the second category, which is to rebut the defense of innocent association. So I'll make use of the case of R versus Paul. The two co-accused are brother and sister that were convicted of incest under the Incest Act of 1908. The allegations were that they had sexual relations with each other during specific periods in 1910. Prior to 1908, incest was not a crime. Evidence was then given that on behalf of prosecution, to the effect that at the time specified in the indictment, the two accused persons lived together in the same house. So the house apparently had one furnished bedroom which had a double bed that bore unmistakable signs of being occupied by two people. Prosecution then tendered evidence to prior sexual relations between the two accused persons and was introduced to the effect that in November 1907, the male accused had rented a house to which he brought the female accused, and in that house they lived as husband and wife for more than a year. At the end of March 1908, the she-bull gave birth to a child, and upon registration, she described herself as the mother of the male bull. And the accused were convinced by the field, arguing that similar effect evidence had been improperly admitted. The House of Lords held that evidence of prior sexual relation between the two was clearly admissible to show sexual relation to each other, and association could be admitted. So in this case, similar effect evidence was admitted. Okay. So, like I've said before, to wrap this up, the presentation of similar effect evidence can have both advantages and disadvantages, which must be weighed carefully by the court. Similar effect evidence has been characterized as evidence of character, evidence of propensity, and is generally admissible except in cases where the probative value outweighs the prejudicial effect. So to wrap this up, similar effect evidence can only be used in cases where it is logically connected to the current case, and it also highly inadmissible if it is prejudicial to the accused.